Hi everyone, my name is Lena Nguyen. I'm a family law attorney licensed in Texas and California. Today I'm going to be talking about what is community property. The character of a property dictates which assets and how the asset is divided in a divorce. Is the asset considered separate property or community property? Here are 5 frequently asked questions to help you better understand community property and essentially separate property. Number 1, what states are community property states? Community property is the law in the following 9 states: Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. Number 2, what is community property? Community property means that all assets purchased or acquired by a couple during their marriage is considered jointly earned and is subject to division upon divorce. Gifts and inheritances are an exception to this law. If you are specifically given a gift or you inherit a property, it is your separate property regardless of whether you were married at the time. Number 3, how do you prove a property is not community property? One way is through an agreement. Couples can agree certain property will not be considered community property by signing a contractual agreement. Premarital agreements and postmarital agreements are examples of these agreements that couples will enter into. These agreements will identify separate and community assets in the event of a divorce. Another way is through what's called Inception of Title. This rule actually dictates that a property's character, whether it is separate property or community property, is based on the time and manner in which the person first acquires an interest in the property. So generally speaking, if a person first acquires an interest in the property before the marriage, the property is considered separate property. And on the flip side, if a person first acquires an interest in the property during the marriage, the property is presumed to be community property. Number 4, does the name on a property title matter? Assets are presumed to be community property regardless of how the asset is titled. Number 5, who has to prove the asset is not part of the community estate? The party who asserts that the estate or the asset is separate property has the responsibility to put forth enough evidence to prove their claim. So the burden of proof actually dictates how much evidence is required to accomplish this goal. To prove that a property is separate property, that party must put forth what's called clear and convincing evidence. Clear and convincing evidence is a high standard, and it requires a proponent to prove that there is a high probability that the asset is separate property.
Thank you so much for watching. Please give this video a thumbs up and subscribe to my channel. Also, if you live in Texas and would like a free self-help divorce kit, please check the description box below to sign up.